I don't know. I'm standing in for, I'm standing in for Professor Chilva. So I'll just do, I'm not sure where she stopped. She gave me some items to focus on, but I'll just, probably when she comes back, she will come and put it better in context. But I'll just do what I can to to make you understand, to treat the topic, the subtopic before me. I believe you started with dissolution of marriage. You've done that. The only basis on which marriage can be dissolved in Nigeria is that it has broken down irretrievably. I'm sure you have done section 15. You've done section 1, section 2. I'm sure you've done section 2, sub 1, sub A, B, C, D. And I will quickly just go over E and F. Now, by the provision of this subsection E and F, I am going to read it. Subsection E and F. Let me start from reading section 2 and read it together with subsection E and F. It says the court hearing a petition for a decree of dissolution of a marriage shall hold the marriage to have broken down irretrievably but only if the petitioner satisfy the court of one or more of the following facts. You've done A, B, C, D. Now, he says that the parties to the marriage have lived apart for a continuous period of at least 2 years immediately preceding the presentation of the petition, and the respondent does not object to a decree being granted. F, that the parties to the marriage have lived apart for a continuous period of at least 3 years immediately. Please, can you put your Sophia Salako? Can you mute yourself? Please, that the parties to the marriage have lived apart for a continuous period of at least 3 years immediately preceding the presentation of the petition. So these are the provisions of subsection 2E and 2F. So when we talk about that, we're talking about the first one is living apart for 2 years, divorce by non-objection. That is what we can term it as. The first one, living apart for 2 years, divorce by non-objection. So when you look at section 15(2)(e) of the MCA, the fact gives opportunity for divorce on the happening of those countless events which break up a marriage, which cannot be provided for in advance. I think that is one of the reasons the provision has been made. Living apart involved, number one, physical separation or physical withdrawal of both husband and wife from each other, coupled with an intention on the part of either of them to destroy the marital consortium. Because it's a different thing if they are just living apart, maybe work or study related living apart. An obligation, so they must have the intention to destroy the consortium. And that is the intention not to play any of the known roles of husband and wife to each other. So this is the cleanest and quickest way out of a marriage that turned out to be a mess to the couple and the society. Yet it should be stated here that all emphasis that mere living apart for a month of Sundays, even several decades, does not dissolve a marriage. I want you to note that. Now, for an effective dissolution of marriage, a spouse must fulfill all the legal requirements relating to divorce preceding and obtain a pronouncement from court that he has due jurisdiction. Now, living apart for 2 years should not be confused with Section 31, which bars petition to dissolve a marriage in the first 2 years, rather. You know, the first 2-year rules. In the Section 30, maybe I should not even talk about that. So where a party seeks dissolution of the fact of living apart, as well as adultery, it suggests that a judge should ascertain if the union has been dissolved or the fact of living apart alone. So there's no way you can model together so many things If you want to rely on this living apart and without objection, the court must ascertain that this is the ground on which we are bringing the petition that the marriage has broken down irretrievably because you have been living apart 2 years preceding the presentation of the petition. The fact of living apart saves the parties so many unnecessary expenses, avoid the exacerbation of the parties' feeling and the destruction of any chance of reconciliation, which is often inseparable from the ventilation in evidence of their charges, particularly if they are bringing it under, section 15(2)(c), in which we have to prove so many things and could be very, very messy. Now, the key elements of living apart may be summed up in the following 5 points. Or maybe before I even go into that, let me say that the seemingly easy way of obtaining a divorce can be marred, because this appears to be a very simple one, might be marred by inattentiveness on the part of the lawyer or the counsel who failed to exhibit diligence. If you look at the case of Ibiwoye and Ibiwoye, 1980, 1 to 3 CCHCJ 78. Ibiwoye and Ibiwoye, 1980, 1 to 3 CCHCJ 78. You can also see the case of Olatunji and Olatunji, 1980, 1 to 3 CCHCJ 225. Now, in the case of Ibiwoye and Ibiwoye, the petitioner and the respondent have lived apart for a continuous period of 2 years, immediately preceding the presentation of the divorce petition. That is to say, since they've been living apart from 6th of June 1978 till the presentation of the divorce petition. Now, his attempt to obtain a decree nisi on this fact failed because he did not add the essential phrase, and the respondent does not object to a decree being granted. Sorry, what was that noise there? So I want you to note it. That it is not sufficient for you to just say that you've been living apart for the period of 2 years. It is very important and necessary for you to add that, and the respondent does not object to a decree being granted. So it is not just premised on the fact that they've been living apart for 2 years. There must also be the accompanying issue that Abdul Rashid Alimi, please can you mute your mic? Abdul Rashid Alimi, mute your mic. Can somebody call the guy to mute his mic and stop disturbing my class? All right. I will just continue anyway, because if people are not diligent in class, mute your mic. Simple. So his attempt to obtain a decree failed on the fact that he did not add the essential phrase, and the respondent does not object to a decree being added. So the poor drafting marked the petition, even though in that case the husband succeeded on the alternative fact of dissertation. I'm going to put down the name of this boy. He's in the market. And the guy is in the market. Just tell him I'm going to penalize him, and I mean it. And I'm going
Please,
to
respect yourself now. Respect yourself now. Lecturer is in class. What kind of nonsense is this?
The other colleagues. I'm going to let's forget him. Thank you, Olafokos. Leave him. Mute yourself. Let's continue. I'm going to penalize him. And I'm just saying it in class. Let nobody come and beg me. And tell him not to come and apologize, please. And I mean it. So, though like I said in Ibiwoye and Ibiwoye, the failure to add the phrase that the respondent does not object to it marred that petition, even though it succeeded on another ground of desertion. But it shows you that it's very pertinent that you base it not just the fact that you've lived apart for 2 years, but that the petition, the respondent does not object to the petition. Also, if you look at the case of Adisa and Adisa, the uncontroverted evidence in the undefended petition was that the wife deserted the matrimonial home on June 3rd, 1976, and the petition was presented on June 8, 1979. The paragraph of the petition reads, the parties to the said marriage have lived apart for a continuous period of at least 2 years immediately preceding the presentation of this petition. The court, in distinctly judgment throughout the petition, the court held, that is the judge, Adeoba J. held, that to satisfy the condition that the parties have lived apart for 2 years, the petition should show that the respondent does not object to a decree being granted. The petition did not contain these averments, so it was dismissed. Reliance could not be placed on Section 2F because the petition did not disclose that the parties have lived apart for a period of 3 years. So it was basing it purely on Section 15.2E. Although the petition, if you look at also the case of Coker and Coker, did I give you the citation for Adisa and Adisa?
No, ma'am.
1980. 1980, 7 to 9 CCHCJ 1. Adisa and Adisa is 1980, 7 to 9 CCHCJ 1. So also if you look at the case of Coker and Coker is 1976, 6 CCHCJ. Excuse me, 1743. 1976, 6 CCHCJ 1743. Excuse me. 1 minute, please. Okay. Now, in the case of Coker and Coker, the petition was founded on living apart for 3 years, and the petitioner alleged that the respondent did not object to a decree being granted. The court remarked that the averment was unnecessary. I'll get to this. We are treating living apart for 2 years. I'll still get to section living apart for 3 years under 15.2F, and I'm going to explain that. But basically what I'm saying, I'm trying to differentiate like this Ibiwayi and Ibiwayi, and differentiate it from Coker and Coker, because under the first two, you cannot only depend on the fact that you've been living apart for 2 years. You must also put in your averment that in the petition that the other party has not objected to the petition. So those are the two legs upon which that petition for dissolution will come for it to succeed. Okay, the court remarked that, so the court said in Coker and Coker, they've lived apart for 3 years. He brought the petition and said the respondent does not consent, has given consent, or is not objecting to it. The court said that it's not necessary under section 15.2F. Now, the key element of living apart may be summed up in the following 5 points. Let me give you 5 points to that. The first one, at least one spouse must regard the marriage as at an end. At least one spouse must regard the marriage as at an end, a complete cessation of consortium. There should be an attitude of mind, a desire to keep to oneself in the petitioning spouse, in which withdrawing from the other spouse is evident. So at least one of the parties that left the house must have the intention that the marriage has come to an end. So one of the parties, at least one part, must regard the marriage to have come to an end. Number 2, If conjugal association continues, notwithstanding a temporary or involuntary separation, it will terminate if either spouse decide not to resume cohabitation. If conjugal association continues, notwithstanding a temporary or involuntary separation, it will terminate if either spouse decides not to resume cohabitation. Number 3, it is immaterial that the separation originates in agreement or spouse simply drifts apart. It is immaterial that the separation originates in agreement or the spouse simply drifts apart. Then number 4, time runs in favor of the party who seeks to terminate consortium, even where he or she fails to communicate the decision to the other spouse. Time runs in favor of the party who seeks to terminate consortium, even where he or she fails to communicate the decision to the other party. I think what this one is saying, if I can really try to break it down, is that the other part, at least one of the party that is seeking the divorce, probably time runs in his favor. Once it moves out and probably leave it, there's a separation. Even if it doesn't communicate to the other party that this time is counting for 2 years. Okay, I think the last one. As opposed to desertion, there is one under D15(2)(d) that talks about desertion. As opposed to desertion, the law does not concern itself with who between the couple resolve to bring conjugal association to an end. Under desertion, the court will concern itself with that fact. But under here, as opposed to desertion, the law does not concern itself with who between the two couples resolve to bring conjugal association to an end. It may be either the petitioner or the respondent. The judge should examine how the original separation came about, what the petitioner's attitude to the marriage then was, and when the petitioner ceased to recognize and continue to cease to recognize the union as a life. Okay, so let me see what else I want to say. Okay, now talking about computing the 2-year rules. Computing the 2-year rules. Let me talk about that. Computing the 2-year rules. Now, to succeed in a petition based on living apart continuously for 2 years before filing a petition, the petitioner must establish 2 elements. The fact of living apart, that is the physical living apart one, and the total lack of animus rivatendi. Animus rivatendi, that is intention to return. Animus rivatendi, the first one is the fact of the living apart. So some of you, maybe you are married and you came to Unilag. You're married, your husband is living in Afghanistan. Like this Abdul Rashid. Abdul Rashid Alimi is married to a wife, and they are living in Afghanistan. So he left Afghanistan because such a person cannot live in a better Canada than Afghanistan. Afghanistan or is in a Congo or Syria, where are they fighting again? Or no, Russia is even good than Ukraine. Afghanistan, you know, Luda. So if Abdul Rashid came to Lagos, because he's in the market, he didn't come to school, he didn't come to class, he came to sell meat because he was selling meat in the market. So if Abdul Rashid Alimi came from Afghanistan, where he left his wife, and his intention was just to come and sell meat, and he's been selling meat for the past 2 years, there has been a physical living apart, but there is no intention to end the marriage, because after selling his meat and making money from selling his meat, he has the intention of returning to Afghanistan to resume conjugal relationship with his wife. So for you to compute the time or to establish it, the fact of living apart and the total lack of animals revenge, that is intention to return. Although this fact is fault-free. We talked about fault-based and no fault-based. That is, the court cannot act on it without probing into fault on either side. It should be satisfied at least at the start of the living apart period, and for a duration of 2 years after, there was cessation or stopping of consortium. The period of 2 years of living apart begins from the point of time when the petitioner started regarding the marriage as at an end. Now, how do you prove physical separation? It's usually not difficult. That one is not difficult. One spouse may simply move out of the matrimonial home, and the petitioner puts it in the statement, in communication or conversation, indicating that he will not return to the matrimonial. Maybe he sent a chat like Abdul Rashid Alimi when he came to Nigeria to sell meat. Maybe he didn't want to return. He doesn't have the intention of returning to Afghanistan. So he will now write a WhatsApp message to send to his wife. So you can use that to prove, This evidence is required because living apart may not start from the date the factual separation starts. So at times living apart, maybe, there are so many instances, depending on the factor of each case. In some instances, maybe Abdul Rashid Alimi had come to Nigeria to sell meat. When he came to Nigeria to sell meat, his initial intention, they've been living apart maybe for 5 months. His intention was, after selling meat, that he will go back to Afghanistan. But maybe he now met another female meat seller, and they fell in love. So he wants to separate from his wife in Afghanistan. So the first 5 months, you can't count it as part of the 2 years, because when he left Afghanistan, he didn't have the intention of not returning. So the computation of time will not start from that first 5 months, because there was no animal rivetendi then. So the computation of time now starts from the time after he fell in love with that second female meat seller. And he will now probably send a message to the wife, Motiria Womi, I found another girl, another meat seller that I love. This Abdul Rashid Alimi, you are in my soup. Maybe we'll see in second semester. And you are going to take thoughts. Even if you run away from family law, you're going to take thoughts. I will show you Shegi. Go and ask Nuga. Nuga in part 4. You'll be my scapegoat all through. Then you know how to disturb class. The evidence is required because living apart may not, like I said, if you see the case of Oladapo and Oladapo, 1913. I said 1913, 2013. It's 11 Lagos LR 75. If you look at Oladapo and Oladapo, 2013, 11 Lagos LR 75. Excuse me. The husband petitioner moved out of the matrimonial home in 2006 and filed a petition on the fact of living apart for 2 years in July 2009. The court observed that the precise dates living apart started was not provided, but however calculated by July 2006, the 2 years were up. The petition was granted. Also, if you can see the case of Okiki and Okiki, 1976, Okiki and Okiki, 1976, 7CCHCH. Okiki and Okiki. Okiki and Okiki, 1976, 7CCHCH, 1933, 1933. Now, in that case, husband left matrimonial home in August 1974, and the wife petitioned in 1975. The petition failed because the court said it's not up to 2 years, but she succeeded on desertion. The petition failed on the ground of living apart for 2 years. Okay. So as evident in Falade and Afalade, where the spouse failed to live together, the lack of solidarity between them is accentuated. The petitioning wife ought that the marriage should be dissolved, as they have lived apart for 2 years preceding the petition, and the husband did not object to the granting of the divorce. The marriage was contracted in Falade and Falade in 1970 as a time when the husband was at a time when the husband was divorced from an earlier marriage with 4 children to care for. The wife was a widow with 3 children from the previous marriage. The couple had a child together from their union. As a result of financial challenges, they could not meet up with the rent obligation, and they were ejected from the matrimonial home. About a week later, the wife secured accommodation and invited the husband to join her. He rejected the offer in a letter wherein he stated that it was better for him to live apart in order to save the deteriorating marriage. It was in evidence that while the parties lived together, the husband accused his wife of being a witch who brought misfortune into his business. But for a year before the ejectment from their house, they did not have sexual relations, that is sexual intercourse. The husband's reason was that he was undergoing a spiritual course in the Aladura church, and he was obligated to abstain from sex. About a year after the ejectment, the wife wrote her husband that she never knew unhappiness until she met him, and his presence dampened her faith in him. The court held that the period of living apart started when the husband rejected the wife's offer to live in the accommodation she secured. By the time the petition was filed, they had lived apart for 2 years and 5 months. The petition was granted. So the unplanned physical separation gave the couple opportunity to evaluate their unexpected incompatibility. Now, I think you see the case of Falade and Falade. Let me give you the citation. Falade and Falade, 1976, 3CCHCJ, 797. In that case, I think the man who was a divorcee married a woman who was a widow. They had children from their previous marriages. They had 1 child together. But when they came together, because of financial pressure, they could not meet up all the obligations. So the landlord rejected all of them. They were thrown into chaos, crisis, and a lot of emergencies. Now the wife eventually secured an accommodation and invited the husband to come and stay there. The husband rejected it and wrote back to her that she's a witch and this and this and that and this and that. So the court in computing the time did not compute it from when they were ejected from the house. When they were ejected from the house, both of them moved to 2 separate places. You know, they went to hang around. Maybe the wife hung with a friend and the husband stayed with somebody else. The court started computing, the court started computing the time from the time the wife invited the husband to come to move into her apartment, which she secured, and the husband rejected it. The good part was that even with that, the separation, the court was able to compute 2 years and 5 months. So the rule of living apart and the party, the respondent not objecting, was able to succeed and apply. Let me see. Now, at times it is not always easy to compute the time. The fact, I'll give you maybe 3 more cases: Okpajobi and Okpajobi, Okeke and Okeke, and Taiwo and Taiwo. Then after that, we'll move ahead. So I'll give you 3 cases to show how difficult it can be to prove the onset of the 2 years or 3-year period. Because many times the facts of the case may not always be straightforward. Now, it concerns spouses who live separate from each other early in their marriage life. Failure to live together makes it difficult to cultivate trust, care, blah, blah, blah. Now, in Opajobi and Opajobi, 1980, Fed NLR 217. Opajobi and Opajobi, 1980, Fed NLR 217. Now, the husband left the matrimonial home for the university to study for further studies. Like Abdul Rashid Ali left his wife in Afghanistan to come to the University of Lagos, even though he goes to sell meat at times. In Opajobi and Opajobi, the husband left the matrimonial home for the university to further his education. He made no provisions for the maintenance of his wife and children, even after, as the wife consented to his endeavor. He said, my wife, I want to further my study. And the wife said, okay, go ahead, go and further your studies. After 2 years, she left the matrimonial home to be near her parents to ease the financial burden of catering for herself and her children. 6 years later, she petitioned to have the marriage dissolved on the fact of living apart for 3 years. Now, the court concluded that the period commenced when she left the matrimonial home to commence with her parent, not when her husband left for the university, because at that time she was heavy with a child for her husband. Now, though there are, in this particular Opajobi and Opajobi, I want to emphasize this, and I want you to listen carefully. You know, she petitioned under the next item I'll be looking at, under 3 years rule, not under 2 years rule. But we brought it here because we are talking about computation of time. Now, there has been a lot of critique about this case because it said that the wife did not leave her parents for her parents' home. You know, she left her matrimonial home to go and live near her parents in order to ease the financial burden. So the critique is that she did not leave her parents' home because she resolved to terminate the marriage. You're talking about intention then. She left because she wanted material assistance to survive the harsh financial condition she found herself in. She should have adduced evidence to the effect that at a point in the 6 years periodical 6-year period conjugal association ended. So that's just about that case. Now, another one is Okeke and Okeke. Okeke and Okeke, 2010. And I always say 19. Okeke and Okeke, 2010. 7 Lagos LR 62. Okeke and Okeke. The husband consented to his wife traveling to Belgium for studies. Initially, they communicated freely, but after a while, she stopped all communications. 2 years after her departure, he traveled to see her, but she did not welcome him. Now, in 2007, she visited Nigeria and he made another effort to resume cohabitation with her, but to no avail. The intervention of their respective parents, friends, and well-meaning relations was fruitless. Instead, the wife suggested that they should make the relationship a subject of prayer. He told the court that the person who prayed for him assured him that the marriage had prospects of success, but the person who prayed for his wife told her that the marriage was over. So both of them visited different prayer contractors. Shortly thereafter, she returned to Belgium and stopped all communications with her husband. The court granted the petition, which was filed in mid-2009, on the fact of living apart for 3 years. The court counted from the wife first traveling abroad. Now, this case, if you look at Okeke and Opajobi, they are contradictory because it has been critiqued also that this is wrong. The period should have been when she broke the agreement, which should have been 2007, when she proposed that the party should make the success or failure of the marriage a subject of prayer. So it has been critiqued that that should be when the time should start computing, not when she traveled to Belgium. Let's look at the third case. Taiwo and Taiwo. Taiwo and Taiwo. 2014, 1 Lagos LR. 2014, 1 Lagos LR 55. The couple in Taiwo and Taiwo have their matrimonial home in Lagos. Now, in 2005, the wife secured employment in Abeokuta, and her husband consented to her moving there to reside with her uncle. That was in 2005. Now, in 2006, she moved out of her uncle's residence and secured an apartment for herself. She did not permit her husband to know her new abode. And in a telephone conversation, she warned him not to visit her without prior notification. In 2011, sorry, please give me a moment. Okay, so sorry, I have to use the restroom. So I think I was in Taiwan. I gave you 2014 one Lagos LR at 55. Now, so I told you that she moved out of the uncle's house. She rented a place and told her husband that she will not allow him to know his new place of abode. So in a telephone conversation, she warned him not to visit her without prior notice. So in 2011, he petitioned for divorce on the fact of living apart. For Lami J, the court held that the couple lived apart from 2015. However, it has been critiqued that this is unsupportable. The earliest time will have been when she left her uncle's residence, not when she secured an employment in Abeokuta. Because when she secured an employment in Abeokuta, it was with her husband's consent, and she moved here to live with her uncle. It was when she moved out of her uncle's house and rented a place and told her husband not to go there. It has been critiqued that this should have been the time when the computation of time should have started. Okay, let me say another thing. When you talk of living apart for 2 years and the other party is not objecting, the next thing we'll be talking about that period must be continuous. Period must be continuous. Period must be continuous. Now, if you look at this provision should be, if you look at section 17.2, section 17.2 of the Matrimonial Causes Act, let me see what it says. Section 17.2. A minute, I'm trying to look at it from my system. Let me read the provision, okay? Section 17.2. Section 17.2 says, in considering for the purpose of section 15.2 of this act, whether the period for which the respondent had deserted the petitioner or the period for which the parties to a marriage have lived apart has been continuous, no amount shall be taken of any one period not exceeding 6 months, or any or 2 or more periods not exceeding 6 months in all, during which the party resumed living with each other, but no period during which the parties live with each other shall count as part of the period of desertion or of the period of which the parties to the marriage lived apart, as the case may be. Now, the provision should be interpreted in its wildest sense to exclude visits one spouse to the another with no intent to resume consortium or conjugal association. So visiting a spouse will not negate living apart if the aim of the visit is to see the children, even if it involves staying the night, so long as there is no sexual contact. See the case of Nwabugwe and Nwabugwe. Let me try and spell it. Nwabugwu. Nwabugwe and Nwabugwe. Nwabugwu. 1974, University of Ife Law Report, LR, Part 2, 280. Nwabugwe and Nwabugwe. 1974, University of Ife, LR, Part 2, 280. I want you to see the English case of Sanctos and Sanctos. Sanctos and Sanctos, an English case. It's an because English Divorce Reform Act of 1969 has an equivalent provisions. If you look at section 2.1 of the Divorce Reform Act, and in that case, Santos and Santos. Let me see the citation. Santos and Santos. Santos, Santos. Santos and Santos, 1972. 2 all ER. 2 all ER. England Royal Reports. 2 all ER. 246. That's 246. Now, where in that instance, in Santos and Santos, the couple cohabited for a few days at the time during the period of 4 years. The court held that the fact did not bar the wife from presenting a petition for dissolution of marriage on the account of 2-year separation with no objection from the husband. Also, I want you to see the case of Ola and Ola. Ola and Ola, 1979, 10-12 CCHCJ 59. Look at the case of Ola and Ola, 1979, 10-12 CCHCJ 59. Now, in that case, during that Ola and Ola, their matrimonial home was in Lagos, yeah. So after more than 15 years of blissful marriage and love you, the husband secured employment in Ibadan and left. Like, what's his name? Abdul Rashid Alimi secured employment to come and sell meat in Lagos and left his wife in Afghanistan. So Ola, the husband, left Lagos after 15 years of a good marriage together with the wife and came to Ibadan. The wife remained in Lagos with the children of the marriage. During the period of 4 years before the petition, the husband visited the matrimonial home, but there was no consortium during that period. His visit was to look up the children. When the petition for dissolution of the marriage on the fact of living apart for more than 3 years, the wife challenged it on account that the husband's visit made the period intermittent. Our contention was dismissed and the petition was granted by Okuribido J. Azide or whatever he is now. Okay, so we've talked about the period must be continuous. I want us to see also it's a fault-free fact. Fault-free fact. Fault-free fact. And it has been said that this section 15, 2E and F is perhaps the only and probably the next one you are going to do. I'm sure I'm not going to be the one to do that with Professor Ochuba. I will do that. Talking about the presumption of death, that one is not even a good example. But this section 15, 2E and F is one of the best examples of the underpinning principle of the no faults based divorce. So, we've talked about period must be continuous. Next one is fault-free facts. Fault-free facts. Living apart is a question of facts, which exist independent or who brought about the state of the facts. So, in this, we're not finding fault. We're not asking the question who left who. It's not a situation in which you're going to be asking the question why and who and whatever. The fact is just that there has been a continuous living apart for 2 years. So where a petitioner relies on the fact that the parties have lived apart and that fact is established, he should be entitled to a decree of dissolution irrespective of his or her share of the blame in bringing about the state of affairs. So when Abdul Rashid Alimi left Afghanistan and did Ojukokoro to come and be selling meat and found another lady selling meat, he can bring the petition for dissolution, even though he was the one that left. So the court is not concerned about fault finding here. The court is not concerned about who caused what and how and everything. It's just based on the computation of time. So when a petitioner relies on the fact that the parties have lived apart, and that fact is established, will be entitled to a decree of dissolution in respect of his or share in bringing about the state of affairs. Unlike the matrimonial offense of desertion, this is different from desertion that you have done. I'm sure you have done before. There's nothing like constructive living apart. The court should not consider the parties' domestic history in order to declare who is responsible for the living apart. Court is not allowed to do this under section 15(2)(e). Okay? So the court should not concern itself with whether or not a spouse committed adultery or any matrimonial offense such as unbearable behavior prior to or during the period of living apart. It is possible that a petitioner's adultery occasioned or accelerated the breakdown of the marriage. But the court should not concern itself with this. The court should ignore those details. If the water of a stream is bitter, the taste at the fountain is undoubted. The guilty or innocent party, is entitled to primacy once the court accepts the evidence of living apart for a period of at least 2 or 3 years preceding the presentation of the petition. So divorce on this fact is a misfortune that befalls both parties, and they both presumably contribute to the irretrievable breakdown. Maybe you could see the case of McDonald and McDonald. I think it's an Australian case. McDonald and McDonald. McDonald and McDonald, 1964. SR, then in brackets. SR, then in brackets. NSW 435. Okay. We can't definitely finish it today. I'll just do the part I can. Okay, you can see the case in Ladipo and Ladipo. See the case of Ladipo and Ladipo. I think you should read it. Don't let me waste time on it. Ladipo and Ladipo, 1980. 1980, Federal NLR 179. In that case, the couples they've been married for 23 years, and before the petition of the divorce, they had 6 children together. And the court found that for an offense that the wife allegedly committed, but which was not disclosed in the proceeding, her husband forced her out of the matrimonial home. And that was how they've lived apart for that number of years when they brought the petition. So also the case of Adiola and Adiola. Adiola and Adiola, 1979. 1979, 1-3 CCHCJ 76. 1979, 1-3 CCHCJ 79. Now, in that case, the husband petitioner asked the court to dissolve his marriage with his wife because they had lived apart for more than 3 years. The story was that his wife's behavior led to their ejectment from their 2 previous accommodations. Maybe she was a quarrelsome woman, I don't know. During his examination in chief and cross-examination, he failed to disclose the wife's behavior, which led to the ejectment. Here, the petition was granted because those facts were not significant to the petition before him. The court's concern was that the petitioner provided satisfactory evidence that immediately preceding the presentation of the petition, the parties had lived apart for a continuous period of at least 3 years. The wife petition, okay, so that is that. Even though he gave the evidence that the wife was troublesome, the court did not concern itself with all those facts about the character of the woman because he had satisfied the court that they've been living apart for 2 years preceding the presentation of the petition for the dissolution of marriage. Now, in the case of, look at the case of Fasson and Fasson. Fasson and Fasson, 1978, 5 CCHCJ 779. Fasson and Fasson. Fasson and Fasson, 1978, 5 CCHCJ 779. Now, in that case, The wife brought a petition against her husband to have her marriage dissolved on the fact of living apart for 2 years without her husband's objection. Her uncontradicted testimony was that her husband abandoned her out of the home after a quarrel. She talked about the nature of the quarrel and everything. However, the court, Okuribido, granted the petition as nothing obliged her rather to provide that fact, nor is a judge obligated to dig into that. Look at the case of Irioye and Irioye too. Irioye and Irioye. 1972, NMLR 288. Irioye and Irioye. 1972, NMLR 288. In that case, the husband tendered a tactless letter in his petition for divorce on the fact of living apart. In that case, well, in that case, I'm just looking at how I'm going to say it because it's quite much and it's quite messy. But what's the basic thing on the underlying factor in that case is that there was no need to descend into the arena of conflict to see who did what, who said what, and all those things that are bitter and dirty. Once the court is satisfied that he's been able to establish that they've lived apart for 2 years, continuous 2 years, all the other messy things that happened, the court will not concern itself with it. So another point we are going to, the next point we are moving to, absence of objection. Absence of objection. And this is very, very important that you should note it because the absence of objection is what makes this different and at times distinct from desertion. Now, the sole distinction between 2 years and 3 years living apart, this is what distincts it from the 2-year rules in 15.2E and 15.2F. What makes it different, living apart, that the petition must certify that the respondent does not object to the dissolution of the marriage. This requirement has engaged the court in several cases because it must be established and this is procedurally, this is a very difficult task because if you're not careful, this can be used fraudulently because you have to establish that the other party is not objecting to it. Now, Bada J. George, whose view must have great weight, ventured to suggest that a petitioner should show that the respondent does not object to a decree being granted by showing that the respondent, so some of the things according to Bada J is that number one, you must, let me just say, these are procedural things. Filed and filled a form of acknowledgement of service of the petitioner and answer no to question number 4. Do you intend to defend the case? In the form, there are procedure, you have to sign. So the man must have filled it and must have filed it and said no. Then he must have filed an answer in which he prayed for the dissolution of the marriage on the averment of the answer rather than those in the petition. Then decline to take any step in the proceeding after receipt of the petition, which contains specific averment that respondent does not object to a decree being granted. Then producing a letter from the respondent where it writes that it does not object to a decree being granted. Essentially, I'm sure there are other requirements. Now, if you go to court as of today, there will be other procedural requirements. But the bottom line is that there must be a strong and overt response that indicates that the respondent is not objecting to it. Now, I want to see. In another instance, another judge, Ajose Adeoguntoye High Court, said that it was for the respondent to make his objection known to the court. This is very important. Either in his acknowledgement of service or in his answer, if any, filed in the registry. Absent, that is silent, should be taken as an evidence of no objection to a decree being pronounced. This is definitely incorrect, as section 15.2e clearly puts the onus of proving the absence of objection on the petitioner. So what type of evidence should the courts be satisfied with? Look at the case of Famoriyo, and Famoriyo. Famoriyo and Famoriyo, 1975, 2CCHCJ 253. Now, in that case, the court remarked that positive evidence of absence of objection was required. Now, in that case, the respondent was served with the petition and he filed an acknowledgement of service, but did not file an answer. The petition was granted on the fact of desertion, but by way of an obiter, the court touched on the issue whether the petition could have succeeded if it was based on living apart for 2 years. The court stated that it is desirable that a party seeking dissolution under section 15.2e should adduce some evidence of the consent of the respondent to a decree of dissolution being made unless the respondent, by his or her answer to the petition, should make a statement to the effect or he attend the trial and say so. The consent of the respondent should not be presumed. So consent should not, at no time, should be presumed. Also in the case of Awoyemi and Awoyemi, 1976, 3CCHCJ. I won't talk about the case. Look at it. Look at fast one again. Now look at the case of Rimori and Rimori. Rimori as pronounced Rimourin. Rimori and Rimori, read the facts of it. Rimori and Rimori, 1983, 3 Oyo State HCR, 1960, 164 rather. See also the case of, let me see, Akinola and Akinola. In fact, I think this is Akinola because the courts, there are so many, some of them, the courts agree that they are satisfied with the no objection notice. Some, they said they are not. In the case of Akinola, the husband did not testify, but in his answer, he said that he has no objection to a decree being granted. But the court held that it was not satisfied to the statutory provision. So see the case of Akinola and Akinola. Akinola and Akinola is 1977, 11 CCHCJ 2599. Okay. There are quite a lot of things, and I'm supposed to take this and the other one. Okay. With the last few minutes I have here, let me quickly just start living apart for 2 years. 3 years rule. And see if I can't conclude, it's either Prof will conclude or you go and I don't know. Now, let's go to, according to section 15(2)(f) of the Matrimonial Causes Act. Let me see what it says. Let me put on my laptop again and read it. Section 15(2)(f). It says that the parties to the marriage have lived apart for a continuous period of at least 3 years immediately preceding the presentation of the petition. Now, I want you to look at the difference between the provision of E and F. You can see that under E, there is a proviso and an addendum to it. It says that the parties to the marriage have lived apart for a continuous period of at least 2 years immediately preceding the presentation of the petition. But it didn't stop there. Now said, and the respondent does not object to a decree being granted. Whereas if you look at F, it just states that the parties to the marriage have lived apart for a continuous period of at least 3 years immediately preceding the presentation of the petition. So the living apart provides a clear criteria that a marriage has hit the rock, a sure proof that the relationship no longer exists. Undoubtedly, there will be cases where couples will agree to part with the conviction that at the end of 3 years, any of them could petition. They are quite, in fact, many times I advise my clients that that's about the best option because it is no longer a discretionary issue for the judge. It becomes a mandatory issue for the judge. Let me see. So there have been a lot of critique also on this issue of living apart. Please, 1 minute. Okay. So this 3-year rules is like if once they have been able to compute the time very well, it's like it's a sort of mandatory for the court. Now the marriage has broken down irretrievably where the parties to the marriage have lived apart for a continuous period of at least 3 years, immediately preceding the presentation of the petition. So, in both cases, the period of the period of living apart must be continuous before the presentation of the petition. And living apart has two elements also here, like I said, the physical and the mental element. So staying separation, physical separation alone does not constitute living apart. I've given you the case of Santos and Santos. It is necessary to prove something more than the husband and wife are physically separated. And the relevant state of affairs does not exist. Why both parties recognize if the marriage, if they are just living apart by work or by education or whatever reasons, even by work, there must be the mental element and the physical element. So in this respect, it is sufficient that in this respect, it is sufficient, it is sufficient that one party recognizes that the marriage has come to an end. It is immaterial that this party is the petitioner or the respondent. This is also founding this part strictly on no fault basis. The party does not need to communicate the conclusion to the other party. So once Abdulrasheed Alimi moves out of the house, he doesn't need to tell Ajia that I am ending this marriage. So the party need not communicate the conclusion to the other party. Now, I don't know if I can, but I don't think I can. I want to talk about household. The party, for the purpose of, I want to look at section 15.3. Provide for that for the purpose of subsection 2E and F. Spouses are to be treated as living apart unless they are living with each other in the same household. So where a party argues that though they live under the same roof, they are living in separate households, the evidence must adduce to that fact. So, at times, what this suggests, same and separate household. So they may be even living under the same roof, but probably living in different households. The English Court Act similar provision applied to the principle of interpreting distraction. Living apart, therefore, means physical separation coupled with intention to end consortium or emotional separation with the same intention. I don't think I can proceed to talk about same or separate household. But before we finish, let me just say this, that talking about the living apart rule of 3 years, divorce by repudiation, as some will call it, there are some scholars that call that the period should be extended in order to preserve the sanctity of marriage. Scholars cited Australia, England, New Zealand, where the periods are now 5 years for the first two jurisdictions and 7 years for the last. A longer time, they argue that it's necessary to adequately show that a marriage has broken down, that the 3 years is not sufficient. Yeah, it's not sufficient rather. So I think I may have to stop here. But basically, I've been able to tell you in this class, it is called the 2 and 3 year rule. The 2 year rule that the marriage has broken down irretrievably, that the parties are living apart, a period of 2 years preceding the presentation of the petition, and that the major difference is that under the 2 year rules, the parties must not object. The respondent must not object. And not objecting must be shown not just in passing. There must be in evidence and everything. There must be a concrete proof that is not objecting. And under the 2-year rules and the 3-year rules, living apart, physical living apart is not only required, there must be an intention, the mental element. So there's the physical element and the mental element. The physical element that the two are indeed living apart, and that there's the mental element, the intention to live apart, and the intention to bring the consortium of marriage to an end. So let me see. I think this is where I may have to call
Ma,
you.
how can we get your material?
No, I don't know. Go and check all the textbooks that have been given to you. Go, I don't know. I'm using quite a number of materials. So get Adekile, get so many materials. Get
Okay, ma.
No, many of some of the cases, I'm not even sure if it's in Adekile, but I don't know. I used
It's not
some
there.
of
That's what I'm asking.
I don't know. I don't know.
Thank you, ma.
Cool. All right. Take care. Enjoy your day. And let me tell Ali Abdul Rashid that we'll meet one day. We'll meet. That meat is selling. He will come and sell it in class.